Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. I would love to turn to our excellent panel of speakers today and get us started on our fantastic presentation. Just starting alphabetically, I will begin with David Fink. Mr. Fink brings over 35 years of experience to resolving family conflict. And after practicing in a traditional litigation for over 20 years, he transformed his practice to focus exclusively on helping families resolve their disputes outside of court, using non-adversarial, humane, holistic, and creative problem-solving approach to conflict. He serves as a neutral in various settings, including as a mediator, a private judge, an arbitrator, referee, and as a parenting coordinator. So thank you for joining us today, David, to bring your expertise to this panel. Next, we have Judge Leslie Landau, who joined ADR Services, Inc. as a neutral after 20 years of distinguished service as a judge of the Superior Court in the County of Contra Costa. The last nearly 10 years of her tenure on the bench focused on family law, culminating in her term as supervising judge of the family court in 2022 to 2023, where she made pivotal contributions to the court's technological advancements and the response to the COVID-19 crisis. Additionally, she was honored as the Trial Judge of the Year by the Alameda Contra Costa Trial Lawyers Association in 2023. So thank you for joining us, Judge Landau. Our next speaker is Judge Anita Santos. Judge Santos was a judge of the Superior Court in the County of Contra Costa as well, with assignments in the Family Law Division, Felony Criminal Trials, the Juvenile Division, and a Domestic Violence Calendar. In addition to her years as a judge presiding over family law matters, she served as a child support commissioner for 2 years, where she presided over thousands of short and long cause hearings regarding child support, spousal support, and attorney fees requests. And prior to her appointment to the bench, Judge Santos was a sole practitioner in an active and successful family law practice. Thank you, Judge Santos.
Thank you.
And our moderator extraordinaire today is Alice Cheng with Candelaria PC. She's a certified family law specialist experienced in handling all facets of complex family law matters. And she practices throughout the Bay Area in all of the Bay Area counties, in addition to in front of private judicial officers like our other speakers today. Her approach to settling matters is amicable whenever possible because settlement can save time, avoid significant financial costs, and protect the family from emotional stress. So Alice is an excellent moderator for us today to discuss how we can use mediation and other settlement tactics in resolving family disputes. Without any further ado, I will hand it over to you, Alice, to take us away.
Thank you, everybody, for joining us today. Hopefully you're grabbing some lunch while we have a chit chat about this topic. First, we're just going to start off with diving a little bit deeper in with each speaker about their particular style, because I've worked with all 3 of you in some context, whether it's in a private case or appearing in front of you in the public court. And I know that all 3 of you do have some similarities, but also very different styles. So I think we're going to start with David on this one.
Because I'm the outlier.
Yeah, well, yes, in part, right? Please let us know, like, how did you get into mediation, and tell us more about your style?
Well, I actually was lucky enough to be exposed to mediation in family law as early as the early 80s, because I happened to be working as a support person in a law firm that actually had a family lawyer who only did mediation. And that was, before it was cool, and right at the beginning of mandatory custody mediation in the court system. So I was always interested in it, and pretty early in my career, I got trained. But my approach has definitely evolved over my long career. I'm definitely highly facilitative. as compared to evaluative. The role of the law in my process is somewhat diminished. I sort of look at the law as, the alternative if an agreement can't be reached. And more than that, I tend to tell the parties and counsel that, particularly if it's a mediation and I'm not in a position to make any decisions, that, persuading me is not really one of the functions. It's more about trying to come together and have constructive conversation. So I usually will say something along the lines of, the one place you get to insist that the law is followed is in the courtroom. Because in the courtroom, a judge is required to follow the law and to apply the law as the judge understands it to the facts that the judge has found. And so most people who are looking for an alternative to that are trying to avoid the uncertainty of court. And as a general rule, the other side is not going to be persuaded by your argument about what the law is or what you think the facts are. They're going to be pretty entrenched in what they believe. So I tend to work with meeting folks where they are, and then how do we bridge those differences if the goal is to have an agreement and not have a third-party decision maker tell you what's going to happen.
Judge Santos, why don't we popcorn over to you?
Sure. Thank you. Thank you for having me, first of all. And I'll probably not the opposite of David, if I can use first names in this setting, but certainly in my 2 years as now a private judge and mediator, I would give myself the label of a hybrid between informative and evaluative. And perhaps that's from the bench background. I don't know. But one of the reasons I think that many attorneys and their clients select a retired judge is they want your expertise, your input, your feedback, your evaluation. Understanding it's a mediation or a settlement conference, and I'm not using them interchangeably, but the goal is the same. I tend to use the informative and evaluative posture. I try to wait until last, but depending on how much time we're using in the negotiation process. But my preference is in person for mediations, and my style tends to be more informative and evaluative, always giving caveats. I mean, I describe everything from it's the luck of the draw as far as your judge and their style. So if you want to know what's going to happen in court, and I'm actually stealing a quote I've heard, then you need to go to court. But you're here to avoid that, right? So depending on your judge, which is the first thing every lawyer looks at, who's the judge, and gets all the information they can. Short of that, you're in this process to settle your case. So I will give my caveated opinion. I will give my evaluations, but what you don't want to get caught up in is becoming a substitute judge. You're trying to bring these parties together. So I like informative, I like evaluative, and certainly with if asked, that's my preference. Thank you, Alice.
Thank you. Judge Landau?
Well, I want to just point out that in the materials, we have a summary of what each of the styles of mediation is: facilitative, informative, and evaluative. Facilitative really focuses more on helping the parties to identify their common interests and work towards finding solutions that meet people's needs. Informative is more telling people about legal rights and responsibilities, but not really weighing in about how things might be decided. And then the most legally focused is the evaluative, where the mediator really focuses on offering opinions or suggestions based on what might happen in court. And like Judge Santos, I think because I'm a former judge, I tend more towards evaluative. I generally will start out more facilitative to see if we can get some progress that way. But in the end, my strength is that I know how judges think. I've made hundreds, if not thousands, of decisions in the context that generally come up. And I can help the lawyers and work with their clients to understand the range of possible decisions that they could be looking at, the expense it would take to get there, and the risks of taking it to a stranger in a black robe rather than deciding it on their own. and armed with that, allow them to bracket their risk and make a decision that is, unless it's a custody issue, which is sort of different. If it's a money issue, if it's something about property division or support, it helps them to bracket their risk and make some decisions based on what the alternative would be, because really you're looking at, let's make a deal. It's either door number one where you decide yourself, or door number two where a stranger in a black robe decides for you. And the benefit that somebody who's been on the bench for many years and done this many, many times, and sometimes knows your judge, is that we can't tell you what a judge would do, but we can tell you how a judge would think, and how a judge might weigh these things, and how a judge might not believe or might not buy or might not weigh the same way that you do the facts that you think you can prove. So I think that although I have some I have a lot of experience being facilitative, I think that people will come to a judge, a former judge like me or Judge Santos, because we can do a more effective job at evaluative mediation than the lawyers can, because we are a third party who can do that, who can say the hard stuff.
I have a quick follow-up question for you, Judge Landau. Can you speak a little bit more about your experience as an attorney in your civil background, and what that brings to the table when you're working with parties now as either a mediator or a private judge?
Sure. I was a big firm partner and did appellate work for 20 years or 19 years. And so I'm a very quick study on legal issues, on factual issues, because as an appellate lawyer, you're a procedural specialist and a substantive dilettante. You have to be able to parachute into a case, learn a new area of law, learn a bunch of facts that were tried by somebody else, and figure out how to talk about it to the people who are going to be making decisions. And in a funny way, it suits me very well for helping parties in mediation, because I can master what the legal issues are if I don't know them. And that's more in a more civil context than in family, because I know a fair amount of family law. But even then, for example, if there's a business valuation, if there's an understanding of how a business works, I can parachute in, learn a lot of stuff quickly enough, and use the skills I used in oral argument with judges to talk to clients and lawyers of their clients in mediation, to help them to understand how these facts might play out, how this law might play out.
Thank you. I'm going to go back to David now for our second broader question. What is the difference between mediation and a judicially supervised settlement conference? And do you have any preferences between the two?
I'll answer the second part first, which is I don't have any preferences, but when I'm approached to do something like that, I'm always going to ask counsel, what are they looking for? And I think the key difference here is that a judicially supervised settlement conference is not confidential. Things that are said in the context of that settlement conference are not precluded from being offered as evidence or argument if you later end up in court. Now, in a lot of departments, of course, your settlement conference judge may very well be the trial judge. And so, well, as Justice Donald King used to say, oh, I just forget about everything I heard in the settlement conference when I'm going to go to trial. You know, sometimes you can't unring a bell. But the idea is that it is not so confidential. Mediation is subject to the mediation privilege, which means what is said in there cannot be used as evidence and can't be repeated. And so it's not supposed to impact the decision by the bench officer at all. So I think the key really is, to what degree do you want to keep the conversations, and particularly what your client might say in the course of that process, out of the hearing or sight of the person who will make a decision. And of course, that's why some people will choose to have a judicially supervised settlement conference by an officer who is not going to be the officer who will try the case.
Judge Santos? Anything to add?
So yes, the beauty of being in the private world now is that you can be hired as private judge and handle a case from, literally filing to conclusion. You can, in fact, sit and be part of a settlement conference, which is the context in my 2 years in this world. It has come up, and I take a second waiver, even though it's part of the hiring agreement standard with ADR services, saying, we know you're our private judge, but we also want to use you for settlement conference, and we understand. I think there's an evidence code that prohibits your settlement conference negotiations from being used later. So I want to just throw that little difference out there. So there is a level of confidentiality in settlement conferences. But the fact that it happened and the fact that certain parties were present, that of course is available and usable. So I think there's some fine hair lines that we'd have to draw in what can be used from a settlement conference. Personally, I like being the hired private judge and conducting the settlement conferences. The benefit is you have much more exposure to the parties and many more options along the line to continue to try to settle a case, even if you have to settle it by piecemeal. So I like that portion in answering your question of what do I prefer. But mediations have their own benefits, meaning you're just hired in this world for mediation. And if it's successful, great. And if it's not, you never see the parties again unless they come back for further mediation. So that's also a beautiful thing. And everyone knows that it's confidential. Just the fact that, nothing can be shared. So personally, I like being the private judge. I'm having a very difficult time when people go away and I have no more ability to help resolve this case. And I say that in jest. I don't personally think about it for weeks or anything of that sort. But I do prefer the settlement conferences and that role, but obviously do them all and have had a lot of success. I would point out that I was listening to Judge Landau describe her style, and I see that our styles are very different. I'm a much more relaxed, humorous, try to be humorous, not often successful. In another life, I think I was a comedian, but more of a down home kind of, casual type of mediation style, whereas Judge Landau is wicked smart. She can drop in, and she's from the East Coast, so I threw that wicked in there for that. She can drop on complicated legal issues where I'm looking at the attorneys to give me your law, explain it to me. I can research it, but we have different style in that way. And I try very hard to connect with the litigants on some kind of personal level, but just much more casual, much a different approach than she is. So very, very quick and adept. So there's a difference between our
fun. I'm funny. I'm fun. We have fun.
Well, okay. I'm not saying you're not.
I'm not intense. What?
Anyway, that's my style. That's a great segue for you, Judge Landau, to answer that question.
I enjoy both roles, both the private judge role in settlement conference and the mediation role. The one thing that's nice about mediation, though, is you don't have to be as worried about ex parte communications. There is no such thing as an ex parte communication. The whole process is you talk to one side, you talk to the other side, and you don't have to worry about confidential information that somebody tells you that's not told to the other side. That's a thing you have to worry about a lot in settlement conferences. You have to get an express waiver to have any separate conversations with one side and not the other side. And you have to be very careful about that. And wearing kind of the blinders. So, you have to unhear things when you go to the decision-making role, if you haven't been able to resolve things in the settlement conference role. And it's doable. I mean, we all have compartmentalized the entire time we were on the bench. That's part of what you do when you do settlement conferences. But one of the things that's nice about mediation is that it can be much more free-flowing. It can be much more organic than the settlement conference setting, which has to be, by definition, more formal.
Alice, I wanted to add a caveat, though.
Yes.
I think a lot of practitioners look at Evidence Code 1152 and think, well, any sort of settlement proposal I might make is in fact protected. And I'm going to encourage all the practitioners to do a little legal research on that. The protections of Evidence Code 1152 are not as broad as most practitioners believe them to be. And so you do need to be careful, even in the context of a settlement conference, as to what is said in there that you might not be able to rely on in court. And just 1152 is a lot narrower than a lot of practitioners believe.
Judge Landau, you said something that piqued my attention. You know, there's a lot of times where in mediation, the mediator is really the one carrying the water, right? They're doing the shuttle diplomacy, going back and forth between the virtual or real life rooms. I was just curious, what are your preferences as far as the setup? Do any of you have a rough idea of how often it is that you are engaging in the shuttling between the rooms, or how often is it that people are willing to really work primarily in the same space, but maybe break out as needed? Judge Santos?
So when I'm doing mediations, so far, the vast majority, in fact, I'd say 98% of them end up in a shuttle back and forth process. I like to start in the beginning with everyone, and I've changed this depending on the case and the request of the attorneys, but generally speaking, start with, so I can give my introductory comments. I can see if there's something that wants to be aired with everyone present, and then we break out. That's the preferred method, and I think that's the traditional method. What I do like, and has happened several times now, is for experts, if there's an issue where experts are involved, that for them to be available remotely. So the parties are in person unless there's someone who can't be, but the experts are available on Zoom, and the experts confer, before or while we are negotiating. So that is my ultimate preferred way of either doing a settlement conference or mediation. And that I find to be most effective. What I'm personally, my personal preference is to get to the meat of the negotiations as quickly as possible. And depending on the parties, I've had some successes. Other times they need that first 2 hours, 3 hours, to get there. And I can't yet figure out how to reduce that time. It just depends on, in my opinion, the emotional progress of each of the litigants, not so much their attorneys. But that is what I'm finding, and that is my preference, in person if we can. Virtual works. It's just more difficult to read body language, more difficult to make sure you have everyone's attention, and that at least parties can continue to work in person with their lawyers, more so, in my opinion, when you're in person versus when everyone's virtual. When you leave a virtual room, I don't know what the litigants do. I've seen that they sometimes either turn off their cameras or go do individual things. And so it's keeping everyone engaged, even if it's just with your attorney, is much more beneficial to me.
David, you actually do something that's pretty unique, I think. Can you tell us about how you format the mediations and your preliminary meetings that you like to do?
So mostly I do things virtually, or at least have since the pandemic. And honestly, that's more for my personal convenience than anything else. But part of my philosophy in working with people is I really want the clients to be engaged as the decision makers. And I want the clients to take responsibility for the outcome from the get-go. In other words, the job of the lawyers is to provide advice, but the job of the lawyers is not to actually make the decision for the clients. So I think Judge Santos does this too. I will still mediate with people without lawyers present. And in that model, I actually don't shuttle, generally speaking, unless it becomes necessary to make any progress. But I generally want everybody in the room. And I do have a rule that I don't keep secrets. And if one party says, when the other party steps away for whatever reason, I want you to know this, but don't tell the other party I told you. I warn them that I will be telling the other party as soon as they come back, because I want there to be transparency. that's my preferred way of working, even when lawyers are present. But sometimes, again, the emotional temperature is such that that can't happen. And so we will do caucusing. Another thing that I have taken to do, just to address what Judge Santos was talking about, which is the how do we get to the problem solving part after we've gotten the download of the positions, is I will hold a pre-meeting with each party and their counsel, usually an hour or less. And the purpose of that meeting is for the client to basically tell me all the things they think I need to know before I try to help them solve their problem. So they get a little introduction to me and some comfort with me. They know that I have heard and acknowledged their point of view, so that then when we do all get together, everybody's ready to get to work and the clients are not feeling like, well, I really need to explain myself before I start negotiating. So I found that to be pretty effective. And for the most part, I usually give counsel the choice about doing this. And for the most part, I found counsel appreciate the model and tend to agree to it.
Judge Landau.
I do not generally find that it is productive to have everybody in the same room, except perhaps for the introduction, if everybody's comfortable enough being in the same room. If they're going to a mediator, that means that either the parties have not been able to reach an agreement or the counsel are not able to get the parties to reach an agreement. And there can be some, especially in family law, there's so much emotion that I find that it's difficult to get people out of their narratives when they're in the same room. And so I find that the shuttle diplomacy works better. Like David, I talk to the parties. I don't talk to the lawyers. I mean, I don't ignore the lawyers, but I am mostly talking to the parties, asking what their concerns are, asking what they really are looking to get out of this, and hoping that the lawyers have prepped them in advance to get out of their narratives, and that the lawyers have been able to get out of their narratives, because sometimes the lawyers have gotten so committed to their legal positions and committed to how strong their facts are that they actually can be an obstacle to the parties reaching agreements. I've had situations where the parties were willing to move much more than the lawyers wanted to let them move. And so by talking to the parties, I'm much more able to get to really where they can reach agreements. As to whether I prefer remote or in person, I actually like in person. I like being with real people. I think that Zoom is fine. I'm happy to use it. What I don't like is having a hybrid. I need the lawyers at least to be in the same venue. It can either be live or it can be remote. Sometimes you can have the clients elsewhere, especially if they don't live in the Bay Area anymore. And like Judge Santos, I do like to have the experts available by Zoom. The times I do prefer Zoom are when there's a domestic violence restraining order in place, because we really don't have the ability to make sure that we keep 100-yard, which is usually the stay away distance. It's hard in the ADR offices to keep them 100 yards away. And you have to monitor things like who's using the bathroom when, because the bathrooms are very close to each other. So I much prefer when there's a domestic violence restraining order in place for us to have the sessions be remote. If there are interpreters, I would much prefer they be live, because it's harder for an interpreter who's on Zoom to do simultaneous interpretation. And it's harder for the lawyers and the clients to talk to each other with an interpreter on Zoom if the lawyer doesn't speak the client's language, second language. It's not a second language for the lawyer or first language, whatever. So I much prefer to have the interpreter on site. It's also easier for an interpreter to go over a document with a client when they're live than if it's up on a screen on Zoom, where the interpreter you don't necessarily want to give the document to the interpreter by sending it over. So I find that it works a lot better if you have an interpreter case, for everybody to be live.
So I'm going to jump around a little bit because I think this might fit a little better. But what do you wish attorneys would do more frequently before appearing in mediation? Judge Santos?
Well, my first and number one would be to have, if you have experts on each side, to have your experts confer with each other. That's my number one request on the more complicated cases, whether it's a business valuation or a tracing issue. Those have been the most complicated when people have been separated for years and now they want to go back and trace and they have experts. And my number one request is have your experts meet and confer so that the attorneys can tell us, or the experts can tell us in either a joint letter or a joint appearance, where they differ and why. You know, spending hours figuring that out and sometimes watching the little hide the ball is such a time consuming thing that doesn't need to occur when you're trying to settle a case. So that's my number one request. And I will say, and I'm kind of responding to a question in the question and answer chat. There's somebody who wrote in about it's easier to convince a jury, and I immediately I'm answering that question, unrelated necessarily to what you just said, Alice. Just generally speaking, I do adopt the feeling, having I was a prosecutor for 11 years and tried, a couple hundred cases. Sometimes it is quicker and easier just to have your trial. When you're on session 4, 5, or 6, do your trial. I mean, I'm not encouraging folks. This is the point of this session, is to settle these cases. But when it's a circumstance where you're just trying to try it in front of your mediator or your settlement judge, and you can't get past that. So that, in response to that question and answer, I don't know if we'll do another training, but that is certainly an option, and an option you can oftentimes discern after an attempt at mediation or settlement. Okay, so I'm sorry, Alice, back to your question.
All good. David, do you have anything to add to the question of what attorneys would do more frequently?
Well, I agree actually with everything that Judge Santos is saying, and I want to put a slightly different spin on the part about, are people really there to make a deal or something else? The distinction I often ask clients or their counsel is to figure out whether it's more important to their clients that their client is right, or is it more important for them to be done? And if the client's really locked into, I have to be right, then mediation's probably not going to go anywhere, because they want the answer to be, this is what I want to have happen, and I'm going to try to, beat the other side into submission. That's not going to go anywhere. Definitely, I'd like the experts to meet and confer. I personally, because I have a lot of experience in this area, I like to talk to the two experts, and I like to ask them, you tell me, where are the places that you disagree? And is it on the data, or is it in the methodology?
Yes.
Just so I know exactly what the problem is, and then we can work on it. It doesn't, it's not like the Monty Python contradiction. I just think the other person's wrong. That's not helpful. Right. I want to know why you think they're wrong. And also just going to talk to speak to another question having to do with briefs. For me personally, I've been a certified family law specialist for over 30 years. Briefs don't usually help me all that much, unless it actually happens to be a novel legal question. I do like to have, ideally, people come in, particularly if they're represented by counsel, with what I call a bullet point settlement proposal, which is essentially a term sheet without editorialization and without explaining to me why this is the fairest settlement that anyone has ever offered anybody in a family law case. That doesn't really go anywhere. It's just, I want to be able to see in an instant where the difference is, where's the place that if we can clear a log jam, other things are likely to fall into place.
Judge Landau, any thoughts about what attorneys would do differently or frequently before coming to you?
I would echo what the other two said. I would add the following. If you have an expert, make sure you understand what your expert's methodology is in advance. Typically, the problem is that the methodology that the parties' experts are using may be different. And if you don't really understand what they did or why what they did may or may not meet our needs, then you don't look very good to your client if, in fact, your expert has not been given the guidance they need or has not kind of done the the methodology quite right. And it's very awkward if you haven't in advance kind of cycled back with your expert, made sure you understand it, because we as mediators don't like to make you look bad when we say, hey, I'm not sure this works very well. I think it's really important to prepare your client. And as David said, if your client wants to be right, then mediation is not right for you. Then you just got to go and either be right or be wrong, but have a person in a black robe decide it. If you can get your client to see that this is a business decision, this is just math. And it's math that's based on what it is you really want, what you can horse trade, what the odds are of winning everything you want, what the odds are of taking it in the ear, how much it's going to cost you in terms of money and time. And as my mother would say, tsuris, which is, Yiddish for trouble. How much is that going to be? How much is that going to cost you? How much is finality worth it to you? And what can you get done? And I often will tell people, if it doesn't matter in 2 years, let it go. And if you can prepare your clients to horse trade, to be creative, to not necessarily divide this and this and this and this and this, but rather big picture, you get this, I get this, rough justice is justice. That's very helpful. But it also means that the lawyers have to not get too into their own narratives or their clients' narratives. They have to be a little bit less the advocate and more the facilitator. And that's a switch that's not so easy. With respect to briefs, I don't need a lot of law, but it's very helpful to me to have the key facts. And the key facts also can include what the parties have already agreed to, because it also, knowing what they've already agreed to helps me to stroke the clients a little bit and say, you guys have done a good job so far. And if I can see also that one has given more than the other, that's a useful piece of information for me to have in advance. And so if you can prepare your clients to be creative, if you can prepare me to understand the key to what I need. And one of the questions was, how much detail? I'm going to read what you give me. If you give me 1,000 pages of stuff, I'll look at it, but it's going to cost you a lot of money. And I don't know that you need me to see all of the background materials. And so sometimes less is more, because it allows me not to get lost in the minutia. The key stuff I need, the key documents, the key pages, sure. But I don't need 1,000 pages of Citibank credit card receipts. It's probably not helpful.
Just to piggyback on that. Oh, sorry. Go ahead.
You go first, and then I'll go.
I was just going to supplement what Judge Landau said, and that is, when you give us that, oftentimes we hear from the attorneys, well, we don't want to be accused of picking, cherry picking and giving you just what we want. But then tell me, look at page 81 for our purposes. The rest is context in case, you need context. So that was just the observation. And the mediation briefs are very helpful, because I expect in your mediation brief, my instructions say, give me your settlement proposal, a place to start, so that when we come to mediation, I know where you are and I know where the other party is. And I say to them, each of the parties, when I'm in this introductory group meeting, if there's a change in your position, other than what you've already given me, tell me that now, because I assume you're starting where you submitted in your settlement proposal. I don't need to know necessarily why somebody's getting a divorce. I hopefully have ferreted that out in the initial call that I have with each of the attorneys. And I do, and unlike David, I try to speak with each attorney if they're a counsel before the mediation or the settlement conference, so that I can ask questions that I don't, so that gives me context, and I don't necessarily need each side to hear it and bring in their emotions. But I agree with Judge Landau. I don't need the full, the package, the 3 boxes, but I do want, and I do ask if there's a propertizer, because you can't agree. So that, or your FL was it 160s or 180s, so that I can see what they have if it's not outlined in your brief. That helps me in that sense. But that's it. So go ahead, David, you wanted to add.
I wanted to offer a slightly different perspective than Judge Landau on the idea of clients need to make business decisions. I think particularly as family lawyers, right, we know that a lot of the content and context of the dispute is often relational and emotional and not necessarily about business. And as a longtime practitioner, I found pretty quickly that if you try to just get the clients to focus on the law and the money and let's just make a business decision, sometimes that's difficult for them because neuroscientists have now told us that 80+% of human decision making is emotional, not logical. So I think as family lawyers, we need to take that into account. And so I tend not to describe this so much as a business decision as it is a lifestyle decision. How much, what is the importance of being done or in all the contexts? Because again, we've all had clients who might be inclined to agree to anything just because they are conflict averse and they want to be done. And as lawyers, we tend to say, oh, well, we don't want you to bid against yourself or make a settlement that is not whatever legally or financially unfair. But sometimes if we can talk about what's under that, so for example, the client who's worried about being financially okay, and the conversation is about what does it take to be financially okay, and less about, well, what are your legal rights and how do we make sure we vindicate them? That's probably going to make it easier for your client to make a decision based on more about, well, where am I going to end up and am I going to be okay, than whether or not the outcome either resembles or doesn't resemble what would happen if you went to court. So just for our family law clients, often for one or both of them, those are almost more important considerations than what are my rights and what can I get.
I don't disagree with that. And I think that's an important thing to think about. But when I talk about a business decision, that's part of the calculus.
It's
And,
financial.
I think that when I talk to parties about this as a business decision, what I'm trying to do is turn down the temperature and turn down the, they're going to have to vent. And yes, of course, there's emotion. There's history behind it. And a lot of the cases we see in private mediation are cases where the parties were married for a very long time, because those are the parties that have enough assets to be able to hire a private mediator, and B, have enough assets to fight about. And so we tend to see people who have a long history together. But my experience is that if you can get them focused on the business piece of this, not putting aside the emotion, but factoring in how much is it going to be valuable for you to get done, and what can you live with? What can you financially live with? What can you live with in terms of moving on with your life? But that's factored into this. But in the end, when it's money at issue, one person's going to pay the other person something, or they're going to divide things in a particular way. And however emotional you may feel about it, the baseline is that there are some legal rules that will apply to you if you don't agree to it otherwise. And so when I say prepare your client for to make business decisions, it's really an effort to turn down the temperature. And although I totally understand and agree that decisions are made emotionally, if you get too emotional in this process, then mediation is very hard to make progress in.
All right, we have a question from the audience. At the recent Contra Costa County Judges Night, there was some discussion about limited scope services with private judges. Can you please elaborate on what this looks like? And I think Judge Santos has an answer for us.
Yes, I was peeking. So the only thing I wanted to say is it looks just like what you would think of. You can hire anybody for private judging through the ADR services. And you can segregate issues. If the one issue is a move away, you can do your move away mediation if you want it, or move away hearing in front of a private judge, and then go back to your public judge for any and all of your other issues, if that's what you wish to do. And so that's what I certainly meant by limited scope. I mean, it's kind of like the concept in family law anyway. Just like you as a lawyer, you can be hired for any one particular issue. Same thing with private judging. That could be custody and visitation. That could, because you need an answer quicker than you can get in public court, for example. It could be long-term spousal support, that one segregated issue. It could be child support, especially with the change in the child support statute and the K factor. I went to that training, but it could be just getting your judgment signed. That's a common service, but that's another example. It could be your business valuation issue. All of those can be segregated. Have your hearing or have your mediation and hearing if you don't settle in front of your neutral in the private world, and then that could be it. So that's what I understand and what I mean when I say you can hire one of us private judges for limited scope services. And anybody else can chime in on that.
I think another really good example would be when you have an issue that really deserves bifurcation, right? Like, you know, we all have those cases where there's just this one issue, and if you resolve that one issue, it kind of shakes the tree loose on all the other little issues that really come underneath that. So maybe date of separation as an example.
Absolutely.
So caveat I do want to offer, though, is that San Francisco does not permit limited scope private judge appointments. They will only do, I have not run into that in any other county. But in San Francisco, your appointment must be for all purposes only. I think you could actually work with your private judge to only do a part of it and have the private judge withdraw, but you won't be able to get an appointment order that is just limited to, like, say, just a judicially supervised settlement conference or just the data separation issue or anything like that.
That's good to know, David. Thank you.
Yes, thank you. And yeah, as practitioners, we also sometimes have our clients, like you said, maybe they're, you know, very stuck in their position, or it's the client that just really wants to hear what we've probably already been telling them for some months, but they need to hear it from a neutral. What is your view of being utilized by counsel as the bad guy who might be delivering a reality check to parties in such instances? And how do you know when you're in that process of mediation, when it's time to pull out the bad guy persona, if you will? Does anybody want to volunteer to take that one?
Well, I don't mind being the bad guy. I'm okay, but actually I'm not a bad guy. When I will talk to clients where counsel sort of signals to me that this is something their client needs to hear about, and let me just back up for a minute, because I also encourage parties to do a pre-mediation, or the lawyers to do a pre-mediation conference with me. So I can hear what the issues are that the parties have, whether there are personal issues I need to know about, whether there are styles that your clients have. Is somebody very data driven? Is somebody very emotional? Are there characteristics that will help me to understand how to talk to them? But when I'm giving a reality check, I don't say you're going to lose. But what I will say is that you have here, for example, an area where the judge has a huge amount of discretion. And so, for example, if we're talking about long-term spousal support, I will pull up a copy of 4320 and I will look at all the factors, and then I'll show them the last one, anything else that might be considered. And I'll talk about how that means that a judge would have a lot of discretion. And here are ways that a judge might look at your case that's very different from the way you're looking at it. And I could definitely see that a judge would think you're only 45 years old and you really can go out and get a job. Or, you know, a judge might think X, Y, or Z, and you could end up in a position that's a lot worse than the situation you can negotiate for here today. And so I will talk about it more about how a judge might look at this differently than you will, and how I would think that you have a really steep climb to convince a judge of your position, rather than saying you're all wet. But I don't have a problem being honest with a client about the difficulty of the position they have and the cost it will cost them, both emotionally if they lose, and also financially, no matter what. And so I don't mind being the heavy, but it is helpful to me for the lawyer to signal to me that it is useful, and I tend not to do it early on. I have to have established some rapport with the parties and understand where they're coming from, and I will only do it in an area where it really matters. If it's a small matter, I think it's probably not a good idea to go there, because if the client then gets upset, then you've lost the big picture.
One of the things that how I tend to approach that with people, particularly with clients, is to ask, well, so what's your assumption? Is your assumption that if you took this to trial, you would prevail? And I might ask, how did you come up with this assumption? Sometimes it's my lawyer told me I was guaranteed to win. And then I might turn to the lawyer and say, did you say that? And the lawyer usually says, I never said anything like that. But the other thing is that most people don't actually understand how the legal system works. So, they think that, well, I'll go in and argue my point and the other side will argue their point, and the judge is going to pick between which one sounds more right. And going back to what Judge Landau was saying before about what do judges look at and how do they actually think about things, explaining that that's not how the judge is not limited to those two options. I mean, sometimes it can be a very clear thing if you've got the evidence and there's a tracing and it's a separate property thing, then maybe we can confidently say, well, yeah, it's probably more likely than not this would happen. But a lot of the times it's like the judge is going to look at it. The judge will decide what the facts really are, and they're not limited to just what one person says and what the other person says. And then they'll apply the law and you'll get your result. But they're not limited to just those things. And sometimes that helps individual clients understand how much uncertainty there is about some other person is going to process this information and come to a conclusion that perhaps neither party even thought of.
And also, I don't need to expand other than to say I don't have any issue with offering an opinion in those contexts. And I explain, this is how I would see it. This is how I view what I've received. These are very good arguments or not as good arguments. And if it were me sitting as your judge, I would be inclined to do, so I don't see that as a bad role. I see that as, it may not be well received. Sometimes you have to take a break after you do that. And I also look to the lawyers to help their client, especially if they're the one that's most in disagreement or most emotionally distraught by the response, to get back to a place to see it differently or to compromise on their position. And I specifically expect that of the lawyers, even when I walk out. They may not agree, but when you ask for the opinion, you have to discuss it, the opinion that's given. So I have no issue with that. I see that we're running out of time, so I don't know what.
Yes, exactly. Well, I think there is a question that that I think will be helpful to both the neutrals and the counsel on this call. What are some of the tips and tricks that you use in tough mediations? Anybody want to take a crack at that one?
I'll just add, well, Judge Landau used the term horse trading. I do that, and I try to explain the most common example that comes up, and not every case, obviously, but I've been very successful in the global, not down to the penny, but the house versus you keep your retirement. That comes up over and over. The person with the larger retirement that people feel they own their retirement. They get to keep their retirement undivided versus the other person that gets the home. Now, you can't do that if you're going to go down to the, fair market value in today's, appraisal of the home, because you're kind of banking on the real estate will continue to grow, the retirement, you have a growth rate. So everyone's going to do their own math. But I find that has been one of the most successful, giving ideas when you're looking at either their propertizer or their property of how to horse trade without getting into the line by line, and reminding both the lawyers and their clients that Watts Epstein, school reimbursements, that's all discretionary. People lock in on those things and in their math. And I find that if your mind indifferent, kinder, gentler, I use humor, humorous ways, that is negotiable. That's not set in stone. That's how I've been more successful.
Has anyone ever used a mediator's offer?
I did once.
Yes, I'm reluctant to do that, but I will do it if counsel insist. I agree with what Judge Santos says. Sometimes the sort of global, let's not try to agree on a calculation, let's just try to agree on a set of terms that everybody can work with, is sometimes an easy way. But the other thing I do is I really actually do not see my role as trying to persuade or convince people that they need to settle. In terms of being the bad guy, my approach would be more like, okay, let's look at what the options that you have are. You can do this, you could do that, you can do that. Here's the pros and cons of each. Which one seems better to you? Right? And say you've got to pick, or you have to say this isn't going to work and I'll let somebody else decide. But I try to just make the choices clear, as opposed to saying, come on, this is reasonable. The other side is offering you a good deal. You should take it. Because in my experience, when you tell anybody that, they're going to push back against you and say, don't tell me what I should do. I don't want to know.
But
I
I would
your
never
opinion.
tell somebody what they
Yeah.
should do. And
Yeah,
I make it very clear up front that this is their process. This is their
Right.
decision. And in no event should they ever think that I am pressuring them to accept something. But when I'm being asked to evaluate the strength of a position, I think that whether somebody is going to stick with that position or not is informed, or should be informed, by how strong that position would be if they were in court, and how
Right.
risky it would be to them, and how much they could live with losing on that.
That's part of
And
help.
it's because the whole process of mediation is bracketing risk. And I don't love a mediator's proposal, though I have done it, and I've done it successfully. I will sometimes do it on a small issue. How about this? Can you live with this? I will propose it to both sides, and they can live with that. Okay, good. That one's done. Put that one to the side. But I think that the most successful mediations are the ones where parties are not looking at the propertizer values and looking at every dollar, because if you're looking at every dollar, you're losing the forest for the trees. And you're minimizing the ability of people to be creative, because as soon as you're looking at dollars and cents, and I've had people talking about cents, and at that point, you're never going to be able to reach an agreement, because it will take too much to line item everything, and parties won't be as happy with it. And the beauty of mediation is that the parties can decide what they really care about and divide it that way, in a way that a judge never could if it went to trial.
David, you want to close us out?
Does that mean a song or a tap dance or something you'd like me to do?
Whatever,
Tell a
however the
joke.
spirit moves you.
I agree with everything that Judge Landau said, and I think the idea of helping them assess risk, and helping the clients to understand that if they're making an assumption that just isn't warranted, then sometimes the reality check that we've all talked about is like, you believe this, and that's fine, and I just need to give you feedback that I think it's a very unlikely result compared to some of the other ones. And I obviously don't have the same imprimatur. I have the imprimatur of I used to litigate, so I know what judges do, and less than these retired bench officers who actually said, yes, I've made that decision and I can tell you what I would do with it. But I do think that is part of our job, is to help them to understand what is possible and real versus what do they just hope for.
Well, thank you all so much. I think this has been a great program. Katie, do you have any closing words for us to close us out?
Yes. Thank you very much to all of our speakers and to our moderator, Alice Cheng. Thank you all for sharing your insights and all of your experience in being actually the ones mediating and resolving and pro-temming these cases.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.